Hello, this is Matt on the Moon Lambeau channel. By show of hands, how many of you out there listening now remember me covering this article from Cointelegraph from January 25th of this year, 2021? Ripple ran crypto's most expensive lobbying program in 2020. By show of hands. I see a few hands out there. Yeah, so some of you are listening. Yeah, nice. Hanging around the Moon Lambeau channel. Well, there's an attorney who has been sharing his opinion, which I very much appreciate, on everything having to do with the SEC versus Ripple case. And in looking at the big picture, he's saying something that I don't see enough players in crypto talk about. I've seen attorney Jeremy Hogan speak about this, and I've talked about it. I've seen articles about it, and I've covered it on this channel. But in the end, one of the ideas that attorney Jesse Hines was getting out there, and he tweeted as much, was that in the end, if you look big picture, this litigation, the SEC versus Ripple and what it means for XRP, in the end, it doesn't mean anything if we don't have Congress take action and provide ultimate clarity surrounding the crypto asset class, because there are so many parts of the United States federal government, so many branches and so on and so forth, that want to take claim over this. And without Congress explicitly detailing who is allowed to oversee what, you have all this infighting within the federal government from all sorts of different branches, and it gets messy, and it gets stupid, and it results in lawsuits that shouldn't exist. So ultimately, one of the paths forward here, it's you need lobbyists, and whether or not you like lobbyists in general, that's how the game's played. And so if you want things to go well, if you're a blockchain company, maybe participate in a greater fashion than we've seen thus far. Now, I do want to be clear that I don't have a legal or financial background of any kind. I am not offering any sort of advice, especially not financial or legal. And you should not buy or sell anything because of anything that I say or write. I'm just an enthusiast that likes to make YouTube videos as a hobby on the topics of Ripple and XRP and crypto in general. That is all that it is. And so I want to share with you this short thread from Jesse Hines, who, again, is the attorney that I cited in the intro. And he wrote, "I feel like I've done so many tweet storms on this, but people still focus on the SEC versus Ripple lawsuit. Here's another tweet storm on this topic. We are wasting time and resources on litigation. We should turn our attention to Congress. Before I start, here's the too long didn't read version. Forget about the SEC versus Ripple lawsuit. Contact your congresspeople and let's get the Token Taxonomy Act through Congress. Better yet, let's get more regulation other than just the TTA, Token Taxonomy Act. I will be referencing the text of the Token Taxonomy Act in detail, and then he provides a link there. Let's start this thread by examining why the court is proper authority in the SEC versus Ripple lawsuit to determine whether XRP was sold as an investment contract. The court's job is to interpret the law. In the instant case, the question is, was/is XRP sold as a security? The reason the court is needed is because the statute is unclear. In 1933/1934, Congress passed the Securities and Securities Exchange Acts and defined a bunch of terms included in the definition of security. One such thing they decided not to define was, quote, investment contract. Well, how about that? A little bit of ambiguity. Yay! Anyway, he continues. Because of that, the courts are necessary to determine what is and what isn't an investment contract, and that's how the Howey test came about. So, to reiterate, the courts are only needed when interpretation is needed as to what the law really means and whether it applies. Imagine if there was something out there that defined exactly when and exactly when not a digital asset may be classified as a security. Enter the Token Taxonomy Act. Exactly. There's a reason he wrote that in all caps, and there's a reason I've been covering that on this channel as well. Because if we had that, and if we had clarity, I mean, that's assuming the Token Taxonomy Act ends up being what we all think and hope it should be, right? I guess that's somewhat subjective, but still, I'm just saying, if you had that, there wouldn't be this uncertainty. You wouldn't have all of this stupid litigation. It's a waste of time and wrecking investors' lives and financial fortunes. Anyway, Jesse continues, though. As for the text of the Token Taxonomy Act, it amends the Securities Act of 1933 and Securities Exchange Act of 1934 to not include a digital token, Put simply, if something is a digital token, it cannot be a security or subject to securities regulation/litigation. So what is a digital token? I have posted pictures in this thread of what qualifies. I'm not going to make any legal opinion on how this applies to XRP. Rather, I'll let you all decide that. So what would passing the Token Taxonomy Act mean? It means that regardless of whether Ripple wins or loses, there is a statute that could trump said ruling, i.e., possibly making that court case only a big deal for Ripple, but not for XRP. For drama queens, I said possibly, right? It's a shame he does have to point that out, but there's always these fringe people that if there's like the least little negative sounding bit of anything having to do with Ripple and XRP, it's like, what? Which is not how most of the XRP community reacts, but that's the reason that he felt the need to put it there. I don't blame him one bit. I encounter this regularly. There's always going to be wheels that are more than just a little bit squeaky, if you got the cut of my jib there. Now, in this case, though, before going further, I will cite that this would still be, if that were the case, like it still would be messy if Ripple, like for instance, if it were found that they couldn't any longer sell XRP, even if XRP itself isn't a security, would still be a problem. Because frankly, Ripple's the greatest cheerleader for the entire XRP ecosystem, so yeah, it would still be a problem. But still, if you had the Token Taxonomy Act, assuming it is what we, in a general sense, think and hope it should be, it would still be better than what the hell we have right now. Anyway, and then Jesse wraps up by writing, could litigation still be needed? Yes, of course it could be needed to determine whether XRP qualifies as a digital token, but I'll be honest. If XRP can't meet the token taxonomy test, there was little hope for it to begin with in the United States. Which makes sense to me. I agree with that. If you have a reasonable guideline and a token can't fit within the parameters of that, especially if it's sufficiently broad and it's not encumbersome, okay, well then fine. As long as everybody's got a level playing field. Now, it does make it tough now because you're talking about XRP. You're looking back before this thing existed. So if you're going to try and apply it to a law that they didn't know was going to exist in the future, it makes it tougher. So maybe you could have some sort of like grandfathering in situation or something like that, because regardless, clearly today XRP is not a security. But then Jesse writes, in conclusion, everyone should find out who their congresspeople are and contact them repetitively until they get the point. We need clarity in digital assets, blockchain, and crypto. And he's spot on there. I think Jesse Hines is nailing it. If we had this, we would not need all of this ridiculous litigation that we're seeing today, which is just wrecking people's freaking lives. And so into this, and I'm going to just touch on this concept, just to give you an idea of what would be needed, perhaps, or the direction at least that the crypto asset class needs to go in a greater sense. It's just, if you want to get to Congress, yeah, he's right about, fine, what Jesse said, yes, of course, contact them. But you need to lobby. Whatever you think of lobbyists, this is the way the game is played, like I said towards the beginning part of the video. And blockchain companies need to participate in a much greater way. And I'm going to illustrate that. Wait till you see some of these numbers I'm about to put up on the screen here. And so you can see Ripple ran crypto's most expensive lobbying program in 2020. That's the headline from this Cointelegraph piece from January 25th, 2021. The first sentence. Ripple Labs spent $690,000 on lobbying in the United States in 2020, which still didn't save the firm from the Securities and Exchange Commission. And so this is an article, and they do have a tilt that's clearly negative towards Ripple and XRP. I've already covered that, so I'm not going through the article again, but I wanted to cite that figure. I already put this article in the wood chipper. Apparently it has revived itself. Well, it's the internet, you know. So $690,000, and Ripple, that's the biggest lobbying program in 2020 in all of crypto. $690,000. How about this? Where do I it's right here. Yeah, here we go. Take a look at this from Statista.com. Leading lobbying industries in the United States in 2020 by total lobbying spending. And so it's broken down by industry. So again, keep this number in the back of your head as I go through some of these. Ripple, the biggest spender, individual spender, $690,000. Now I am comparing to entire industries, but let me assure you, these numbers are going to be nowhere close to one another. Pharmaceuticals / health products. Not surprisingly, that's where most of the lobbying money is going. And this is in millions of US dollars. So $306.23 million spent pharmaceuticals and health products. And remember, again, Ripple, $690,000. For pharmaceuticals/health products, $306.23 million. For electronics, manufacturing, equipment, different industry, $156 million. You see how far off this is, right? Insurance, $151 million. Real estate, $131 million. Business associations, $119 million. Oil and gas, $110 million. Hospitals and nursing homes, $108 million. Ripple, $690,000. It's like, that's a rounding error. Like, do you see what I'm saying here? And I'm not going to cover it in this video, but I'll highlight this too, because I covered this. This is from January 28th this year, also from Cointelegraph. Crypto industry jumps into lobbying in response to FinCEN. And so for some people, there's a little bit of a push, but I'm just telling you, in the world of crypto, there is not sufficient lobbying. And so if you want your interest to be known and to have an impact from a legislative perspective on what Congress has to do with all of this, you need to lobby further. And it can't just be Ripple. But if there were sufficient lobbying along the way, because some entities do have deeper pockets, perhaps something like this never would have happened in the first place, and that's what I wanted to highlight. So you can let me know what you think in the comments below, but I'll wrap up there. I am not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.